former Chief Justice of India and the author of this judgment on the Aravalis, which is being debated all over the country. Justice Gavai, I hope you will go through my questions and give me appropriate replies, because fundamentally, and I would like to begin by saying this, Justice Gavai, that I have a fundamental disagreement with your judgment, which as a citizen of India, I'm entitled to have. The Aravalis stood for 2 billion years. The judgment that has redefined them was delivered 3 days before your retirement. What was the hurry, Justice Gavai? The judgment was delivered on 20th November and you retired on 23rd November. What was the tearing hurry?
See, I have been monitoring this issue for more than 3 years. If you go through the judgment, we had raised, firstly, see, judges are not supposed to justify their judgment, but since this is an important issue and there's a misconception about the judgment, I agreed to speak to you. If you go through the judgment entirely, the difficulty is that the persons speak about the judgment without even reading them in the entirety. So if you go through the entire judgment, I had given the entire narration as to how the matter arose. There was some issue with regard to the difference adopted by the various states with regard to definition of Aravali hills and Aravali ranges. So in order to settle those matters, we heard the matter on number of occasions. Various issues were framed, and after hearing the matter, once you hear the matter at length, if you don't decide the judgment, it's like
Justice Gavai, may I ask you, how can you pass that comment on me on my program that I have made my judgments on the issue without having gone through the judgment? I would politely, completely disagree with this presumption of yours and remind you that I have seen your judgment in entirety. In fact, no, I don't think you can pass a judgment like that, pass a comment like that on my observations, sir. I take offense to that. Having said that.
What I've seen on your program is that it is being projected as if we have given a complete license for mining in the Aravali Hill, but that's not correct. If you go through the judgment, we have in fact imposed certain more restrictions on mining in the Aravali Hills and ranges.
No, sir, your own judgment makes it clear on paragraph 30 that your final word went against the amicus curiae, who is a friend of the court. Very explicitly, Justice Gavai, in paragraph 30 of your judgment, it notes that the amicus curiae had stated in his submission, quote, if the definition as recommended by the committee is accepted, all the hills below the height of 100 meters would be opened up for mining, and as a result, the Aravali hills and the ranges would lose their continuity and integrity. It would totally endanger the environment and ecology of the mountains.
So therefore, if you read the further parts of the judgment, we have considered the rival submissions of both the parties. We have accepted the report of the committee, which was consisting of various experts, various representatives of the state governments, and then we, on a surrender pattern, we have specifically directed that no further mining activities would be conducted.
Justice Gavai, in fact, in para 31, the arguments of the Additional Solicitor General have been documented. I've read that as contradicting what the amicus curiae had said on the premise that, and I quote, it would exclude large areas from the Aravali hills and ranges. She, however, submitted that if the definition as suggested by the committee is adopted, unquote. If the amicus curiae, who is a friend of the court, has explicitly taken the view contrarian to the committee view, which has ministry at its helm, which has government at its helm, shouldn't the court have taken the view of the amicus and not that of the government pioneered by the ASG?
See, Mr. Arnab, the court is required to take into consideration the submissions of both the sides. The court cannot accept, it's not necessary that always the court has to accept the submissions are made by one behalf. Maybe the learned amicus is a friend of a court. The court has to consider all the aspects, and after considering the aspect, the court comes to an opinion. So it is not as if that we have to accept the arguments.
No, but the amicus curiae, respected Mr. Justice Gavai, was going by the FSI criteria, but it said that the FSI criteria better preserve the ecological integrity of the Aravalis. Mike, with due respect, to you, Justice Gawai, the FSI is comprised of India's topmost and most respected experts on matters of ecology and environment. Does that not matter to you? Are the experts less aware than the government? Or for that matter, less aware than the judiciary?
Mr. Arnab, the FSI was also a part of the larger committee which was appointed by the court. The committee consisted of various experts from various fields, including the representative of the FSI. And the report which was submitted was not only by the government, it was a report of the experts.
Sir, I'm quoting from your judgment, para 27. The FSI had clearly defined the Aravallis in 2010 as, quote, underslope over 3 degrees, foothill buffer equal 100 meters, interhill distance or valley width equal 500 meters, and for the area enclosed by the above defined hills from all sides. What was the need to revisit this definition in the first place?
There was no question of...
Why did you have to revisit this definition in the first place?
So therefore, I made a submission that the comments are made without reading the judgment. If you go through the earlier parts of the judgment, the necessity was felt because all the 4 different states applied different yardstick insofar as the definition of Aravalli Hills and definition of Aravalli ranges are concerned.
But that can't be a reason, sir. The fact that the old definition... Please, the fact is the old definition... The fact is the old definition recognizes slope, buffer, valley, enclosure and continuity, the very elements that make a mountain range a living ecological system, not a collection of isolated bumps. And yet, the court walked away from it. Why?
The court has not walked through it. On the contrary, if you read the operative paragraphs as well as the earlier paragraphs, we have specifically said that on a Saranda pattern, the MSAP has to be prepared wherein the mining which it will provide, which are the areas where the mining will be prohibited and where the sustainable mining would be permitted.
Sir, I would request you, Justice Gawai, there is a precautionary principle in law. The precautionary principle applies in this case, doesn't it? The precautionary principle in environmental cases means taking preventive action to protect the environment from serious or irreversible harm, even when there is no scientific evidence which is not fully conclusive. This means, as per precedent of the law, the onus is on precaution and safety. Why didn't you apply? I would like to ask you, you have been the Chief Justice of India. The nation wants to know from you, you've been Chief Justice of India in this case, why did you not apply the precautionary principle in this case? There have been innumerable precedents of precautionary principles being applied by the honorable courts on matters of environment. I don't find those quoted in your judgment. May I ask you why?
If you read the operative part, it is very much clear that unless the MSAP is finalized by the IFTRI and finalized by the MOEF, no further mining licenses would be granted.
Justice Gawai, Vellore Citizens Welfare Forum versus Union of India, 1996. The Supreme Court declared the precautionary principle a legally enforceable principle crucial for sustainable development and shifted the onus of proof onto polluters. MC Mehta versus Union of India, Taj Trapezium case, 1986. The Supreme Court used the precautionary principle to stop industries from burning coal near the Taj Mahal, recognizing harm from pollution. I am not an advocate, but I'm asking the former Chief Justice of India, a matter of principle, why did Justice Gawai not apply? Why did the 3-judge bench not apply the precautionary principle in this case?
If you kindly go through the operative part, clause 4 and 5 make it very much clear that unless the MSAP is finalized by IFTRI and MOEF, no further mining leases will be granted in all 4 states in the Aravalli Hills.
Sir, the precautionary principle means that in matters that are likely to affect the environment, it is not required to prove that the activity will cause harm, but that the activity is prohibited unless it can be established that it is benign. No one is suggesting here that deforesting the Aravallis will... Sir?
What does the prohibition on the new mining licenses amount to?
Okay, sir, then let me ask you the AP Pollution Control Board versus MV Naidu case 1990 to 2000. Landmark Indian Supreme Court judgment that reinforced the precautionary principle, established the right to clean water as a part of the right to life, Article 21, and placed the burden of proof on polluters. All these cases were there for you to look at, sir.
We have looked at the cases, and this is T.N. Godavaram and N.C. Mehta are the continuing mandamus proceedings, they are not as if we have closed the matters.
What do you mean?
The
It's not as
matters are
it.
continuing.
Sir, I'm asking. So you're saying the matter is not closed?
Matter is not closed. We have directed the MSAP to get the report. The MSAP report will come to the Supreme Court. Supreme Court will find out wherein the mining activities are to be permitted and where they are to be prohibited. It is not as if that the matter is closed.
Sir, but you've not looked at other cases which were in the public domain. There is a May report by the government. It's titled Detailed Action Plan Aravali Landscape Restoration, in brackets Aravali Green Wall. The irony is this report was published by the Ministry of Environment and Forests. It's not even an old report. It was published in May 25, just 8 months before the Supreme Court redefined the Aravalis. It involved the Forest Survey of India, state forest departments of Delhi, Gujarat, Haryana, Rajasthan, along with German Cooperation for International Cooperation. Now, this report was in the public domain and the nation wants to know from you, Justice Gawai, as the former Chief Justice of India, would you see it the other way, that this report had very much established the threat to the Aravalis? 8 months before your judgment, your new definition allows for leeway by the mining players to exploit an already depleting resource.
Mr. Arnab Goswami, it is firstly not the definition provided by the court. It is the report of the committee of the experts. The court found that the report was liable to be accepted subject to the further requirement regarding, I am again repeating we are again going to the same
So you don't completely agree with the government's version, which the government says we are only going by what the Supreme Court says. You are saying you're only going by what the government told.
We are going by what the report of the experts, of which the FS was also a party. We only accepted that, and in addition to acceptance, we imposed certain stringent conditions which would protect the mining activities. Unless the MSCP is finalized, no further mining will be permitted.
Sir, you've seen you've seen the report.
If you kindly go through paragraph 4 and paragraph 5 of the operative order, it is more than clear.
Sir, you have seen the affidavit out here, sir, of the government which was filed in this case, because I have gone through it in detail. It's 2000. You say I have not seen the reports, but I have read every word of the 2,334-page additional affidavit filed by the Ministry of Environment. Sir, I am very detailed in my work. Sir, the fact of the matter is the government is trying to institutionalize mining as a core objective, not as an exception, by formally designing a framework whose purpose is to enable exploitation, mining inside the Aravalis.
No, but then we have not accepted that. We have specifically stated that unless and until MSAP, the Management of Sustainable Development Plan, is finalized, no further mining leases.
Sir, may I ask you a question, sir? You also said, sir, now that there is considerable public outrage on this matter, and by informed people, not uninformed people, do you believe that if necessary, this matter should be looked at again, reviewed, discussed?
I have always stated that the law has to be static, law has to be developing, law has to be organic.
Yes.
We have, on various occasions, wherever we have found that earlier orders are not correct, the courts have always corrected them.
So
therefore, I was not inclined to speak to you because the matter may come in review, and normally the author of the judgment should not speak about the judgment. But since you insisted that this is an important issue pertaining to environment,
yes.
So if the subsequent benches find that something more to be done, it is always permissible.
So
the TNF Godavarna is the continuous mandamus process.
So it can come up for review. I mean, you're not. I mean, your view is given. I'm sure you've kept track of the public discussion on this matter, sir, over the last few days, and the amount of attention it has got.
If the court subsequently finds that something more needs to be done, something needs to be corrected, the courts can always do it.
And the government should be open to review as well, given all the expert opinion, others, it can be put through review again, this decision, this definition, in public interest?
So I can't comment on what the subsequent, because I am now I can't be a part of the bench now, I am out of the system. Wherever the matter is brought before the bench will always take into consideration all the aspects.
Sir, is the Supreme Court adjudicating mineral potential or environmental protection?
It is considering environment protection, and if you go through the various orders which preceded this order is not passed in a day. It is passed over an exercise which was undertaken for last more than 1.5 years, insofar as Aravalis is concerned.
So
And
the government is portraying this as a Supreme Court mandated environment protection, as an economic loss, building a grievance narrative to reopen mining on revenue. My point is, sir, you are the author of this report. I have read every word of the report. Of the judgment. I believe there needs to be some balance between the views of the government and the concerns of the citizens.
I have always been advocating the concept of protection of environment, protection of ecology, and the sustainable development. So wherever there is a conflict, a balance has to be given. The environment has to be protected. Ecology has to be protected. I must have authored around 18 to 20 judgments in last 3 years for the protection of environment. And the courts are always, it is always permissible for the court if there is something more to be done, something to be corrected. The courts are always open to it.
Sir, matters are taken suo moto by the courts.
Yes, sir. T.N. Godavarna is a suo moto. MC Mehta is a suo moto. MC Mehta is on a postcard of...
but this was a suo moto as well.
This was not a suo moto. If you go through it, the concerns were raised by the various states that there is no consistency insofar as the definition of Aravali hills and ranges is concerned. And therefore, in order to bring a common, uniform definition, the court was required to go into all these issues.
So what stops anyone from redefining? Sir, tomorrow somebody will define the Ganges. Tomorrow somebody will redefine the Himalayas. I said the other day with respect that the Supreme Court of India did not create the Himalayas or the Aravalis.
I have already told you it was necessary in order to protect the illegal mining activities which were going on. The various states were saying that it is not in the area doesn't fall in Aravali hills and therefore the mining can go on. In order to avoid all that, we were required to pass those directions.
So I think that, okay, so here's the point. Now, in this particular case, Justice Gawai, the nation is angry. 80% of the people feel there should be a revisiting of the judgment. What is your view on the need on revisiting the judgment? Because the government is taking a very stern, inflexible position. You're the author of the judgment.
I can't make any comment on that because any comment by me may be prejudging the issue because I am out of the system. I don't want to make any statement which may have a direct, indirect effect on the proceedings that may arise in the court. And that is why I was reluctant to speak because the judges before whom if the review is filed are always entitled to take a relook at the matter and take appropriate action. I can't make any comment.
Well, I appreciate your coming on air tonight because I got a chance to put some straight questions. I hope you will also say, sir, today that after this interview, you would not say that I have not read the judgment, and I hope you find the merit in the questions that I have phrased before you. Because I believe Justice Gawai that the judiciary is important, the media is also important. It's important for us to get the opportunity for this interaction.
I have due respect for the media, but I again say that you have not read the judgment completely. If you had read the judgment, the first 2 or 3 paragraphs you would have come to know as Aravali ranges.
Well, I mean, everybody is shooting off the other shoulder, sir.
So anyway, thank you very much.
Yeah. Well, thank you very much, Justice Gawai, and thank you for coming on Republic.
Good night.
Thank you. Ladies and gentlemen, that's Chief